Apologies, everyone, to keep you all waiting. Sorry, it just had some technical issues.
All right,
Hello.
Vishnuji, can we start?
Yes, ma'am. Yes, we are
All
live.
right, thank you. All right, good afternoon, everybody. Thank you for joining us. To keep it really short so that you can hear Sonali speak, for the uninitiated, I hope you've ended up reading about Sonali on our broadcast materials. Uh, I would just like to say that as a precursor to her starting to speak, thank you so much, Sonali, for agreeing to do this. And I know I
My
can always
pleasure.
count on you for agreeing to my educative pursuit extensions. So thank you so much. And for everybody else, I'd like to tell you that other than everything else that she is so prolific at, Sonali has always been somebody who I know as the most hardworking person to prepare on a guest talk. I have never seen anybody else prepare so much and work so hard at wanting students to learn. So I hope you end up taking back a lot after the end of today. Thank you so much, Sonali. Again, over to you. Let's not waste more time.
Thank you so much for the kind words. And now I'm a little scared because I'm not sure if I'm able to live up to those words with my preparation today. But I do hope, that in case that anybody has any further doubts, I think Akansha, you're there to clear them up. But even I'm available to clear anything post today's talk. Today's topic is obviously a very interesting one, which I am personally always interested in. And it sort of is it's a very interesting topic only because it lies at the heart of most arbitration proceedings. It's Section 9, which means, that's the provision by which parties can seek interim reliefs from court in aid of arbitration proceedings. So these are interim measures. And in any dispute, you can always count on an interim hearing to be the kind of, hearing which draws first blood. So it's very crucial to see who sort of gets the upper hand if they win that particular interim proceeding. I will be dealing with the Amazon future case just to give you an idea of what's going on in that space. So you will also realize from that case study what I mean by saying that, who wins each round becomes very crucial, even while your arbitration is going on in parallel. So Section 9 the journey of Section 9 has been extremely tumultuous in this country, over the decades. And, finally, I think there is some resolution to several debates and disputes about the facets of Section 9. So I do hope to take you on this journey in today's talk. And obviously, the time that we have is limited. It's very short. But, what my idea is that you should just know the main broad, issues that have always cropped up in interim proceedings, academically as well as from a practitioner's perspective. I'm happy to give you thoughts and experiences that have sort of happened in my profession. So when you actually sit to study this topic, and I'm sure Akansha is going to do a fabulous job taking you through more details and more nuances. But when you actually sit to study this topic, at least, I would be glad if you are able to approach this subject with certain, degree of knowledge from today. So having said that, let's start. Interim measures, I'm sure you all know, are always made to protect the interests of parties or to preserve the subject matter of the dispute while the main arbitration is going on. So obviously arbitration proceedings will take their own sweet time. The award will be challenged, could be challenged further. So in the meantime, obviously the parties have to be satisfied that their interests are protected in terms of a status quo on a particular proceeding, or say a receiver gets appointed, or any other kind of interim relief which is necessary in terms of the nature of the dispute. So there are two provisions in the Arbitration Act which basically give you interim measures. Now, I understand from Akansha that you are aware of the way the Arbitration Act is structured in Part 1 and Part 2, right? So just to give you a very quick snapshot before we get into interim provisions, is Part 1 deals with provisions where the arbitration is seated in India. Seat essentially is the concept by which your arbitration, which is obviously a contractual dispute resolution mechanism, gets routed to a particular court of a particular country and the laws of a particular country. And that is a very important concept. So every arbitration will have a seat which is chosen by the parties. Now, when parties choose the seat of arbitration to be in India, that is when Part 1 of the Arbitration Act will apply. Okay. And within Part 1, you can have two types of arbitrations. You can have one type where both parties are domestic, Indian incorporated companies, for example, or two Indian individuals, for example. That's a pure domestic arbitration. But you can also have an international commercial arbitration seated in India, which means one of the parties is a foreign corporation or a foreign individual. So this distinction is a little important because as you will study the Act, you will see that there are two different standards in certain provisions for purely domestic arbitrations as well as an ICA, which is International Commercial Arbitration, seated in India. Thereafter, Part 2 of the arbitration deals with purely enforcement of foreign awards. Okay, so that provision, that part of the Arbitration Act does not have any substantive provisions related to the conduct of the arbitration at all. It just means that suppose you get an arbitration award from Singapore or London, and your assets are located in India, you will bring it to India to enforce in accordance with the provisions of Part 2. So just giving you a preface on the structure of the Act. Now let me come to Part 1. In Part 1, like I said, because the seat is in India, there are more substantive and more elaborate provisions. Two of them are important for today's discussion. One is Section 9, one is Section 17. Now, Section 9 of the Act provides for interim measures from courts, whereas Section 17 provides for interim measures from the arbitral tribunal. Okay. Now, the kind of interim measures are identical. If you actually look at the text of 9 and 17, you'll see that, that power is the same. Like preservation, interim custody, sale of any goods, or any other interim measure, injunction, appointment of receiver. So these kind of provisions are the same, but the application differs now. Typically, what parties used to do in the past is that they were not very interested in going for the actual arbitration. They used to try and file a Section 9 in court even before the arbitration used to start, because you can approach a Section 9 court even before. Earlier, you could do it during, and then you can also do it after the arbitration award has been passed, but till it's confirmed. So there was a very long period by which you can really approach a court. So parties used to do this. They used to first go file a Section 9. Now, obviously, a court is going to look at the whole dispute from a prima facie angle. They're not going to get into deep, merits of the matter or evidence of the matter. From a prima facie view, they used to pass an order. So the parties used to sit on that order because obviously, they've drawn first blood, and why should they then, go and initiate arbitration, and then why should they incur more costs? So thereafter, the 2015 amendments have come up with a very sensible amendment, and they've said that first of all, the timing of approaching court has been amended. You can approach a court only before, okay, or say after the tribunal has passed the award, but you cannot approach them during the arbitration tribunal's duration once a tribunal has been constituted. Now, this obviously means that if there is a tribunal, you need to go to the tribunal for interim reliefs. You don't need to come to the court. You have to come to the court only if you are able to show that the tribunal's relief is not efficacious enough. Okay, so that's one amendment that has been introduced, is to say that if the relief is not efficacious, and we can discuss a few instances where we feel that, okay, it may not be efficacious, then only a court will interfere, otherwise not. So suppose you approach a court before constitution of the tribunal, obviously you don't have a choice, you will go to court. And the court passes an order, you have to initiate the arbitration within 90 days, which means earlier how parties used to just sit on their awards is no longer permissible. You have to initiate arbitration, otherwise your order falls away. So that is certainly an important amendment. The other amendment, like I told you, is the threshold amendment, which is that you have to satisfy the court that if you are approaching the court in the duration of the arbitration proceedings, why are you doing so? Why is it not an efficacious remedy to go to the tribunal? For example, if there is a sale of a property that's happening in 2 days, your tribunal may be, say 3 retired Supreme Court judges with really, busy calendars. And you may have written to them saying that you want a hearing, but they're unable to accommodate you in terms of dates. You don't have a choice. Then even though there is a tribunal, you will go to court urgently overnight and say, look, there's no other efficacious remedy. We would want to come to the Section 9 court. The other instance is when I will deal with foreign seated arbitrations. You will realize there's certain situations where even though there is a tribunal sitting abroad, say in Singapore or London, and they may have the powers to give you reliefs, but you don't have a way of enforcing them. And here your property is being sold away in 3-4 days. You'll still come to a Section 9 court and say that, look, it's not efficacious to go to the foreign tribunal. So these are arguments that you will obviously make. The idea of a court interfering in a Section 9 proceeding is not to frustrate or to sort of take over from the arbitrator. The idea is to aid the arbitral proceedings. And courts are obviously conscious of this fact that they are not going to overstep their boundaries in terms of passing interim orders. And the idea is only that the tribunal is not prejudiced in terms of the preservation of the actual asset. Okay. Now, the other important thing to note is that sometimes parties also choose Section 9 proceedings over going to arbitral tribunals if certain non-parties are involved. So, for example, I'm sure you all know that arbitration proceedings are strictly bound between the parties to the arbitration agreement. But sometimes there are, say, a bank is involved, a bank guarantee is involved. You may have a certain amount, or you may have some other third party which is creating interest in that property. You may want to injunct them. Then a Section 9 is the more efficacious remedy, because the court will be able to pass an order to bind non-parties, and arbitral tribunals' powers in that sense are a bit tied up. Now, this is just the more theoretical aspect. I think I do want to quickly share a few practical tips of Section 9 with you straight away before I go into the more complicated angle of Section 9, which is for foreign seated arbitrations. But whenever, sort of practically speaking, whenever you are drafting a Section 9 application, you have to be very careful that your interim relief has to tie in to your final relief that you will be seeking in the arbitration. Okay, that's important. Don't think your Section 9 scope is so broad that your arbitration can be, say, on point X, but because the sun, the moon, and client is telling you to Section 9, then you have to be very careful.
Sonali,
Say
I
that,
think there's a
for
slight lag.
example,
Maybe you can back up.
Sorry.
Sorry, I think there was a slight
Sure,
lag.
sure.
Can you maybe back up a little bit, maybe like some 15 seconds or something? Repeat it. Yeah, you're frozen again.
Sure, happy. So
yeah, much
just
better. I think you're back.
Is this better? Yeah. Okay. What I was saying is that you have to be careful while drafting your Section 9 reliefs to tie into your final relief that you will be seeking arbitration agreement in arbitration procedure. So, for example, if your arbitration relate to agreement for
Sonali, I still think maybe you can.
it's a less
We are
track.
also getting an alert that. I'm sorry to interrupt you, Sonali. We're getting an alert that your bandwidth is low. So maybe to save on your bandwidth,
No
you can
problem.
switch off your video because otherwise your voice keeps breaking.
Oh,
Yeah.
okay, maybe I can
So
just keep
sorry.
my camera.
Yeah. Yeah.
Is this better?
Yes. Yes. At least we can hear you. So you were telling us about
Oh,
the Section 9 practical tips.
into your final reliefs.
No. I think there's still
The
some issue,
increase
Sonali. We
the
can't hear
hope.
you.
Okay.
Sonali, we can't hear you. Sorry. Apologies, everybody. I think we've lost connection with Sonali. Let's try and get her back online.
Hi, Akansha.
Yeah, hi.
Hi. I was wondering, since Sonali told us that next she's going to cover the complexities of Section 9 vis-a-vis a foreign arbitration, do you think meanwhile we can talk about the exception in Section 2 too, so that the students can um, learn that before she's back?
Yeah, but I think she's already going to talk about it, and I think she already mentioned Section 2.2 in the beginning of her talk.
Okay, okay,
Yeah. Did
sure.
you just
I missed
join
that.
in?
I'm
Yeah,
sorry.
yeah, yeah. She spoke about part one, part two, and how
Okay,
2015 has a sensible amendment.
okay.
That's the word she used.
Perfect, perfect. All
Yeah, yeah.
right.
So it's been done. Yeah, which is why this is where she actually wanted to first talk about the India seated Section 9 practicalities and then move to foreign seat Section 9.
All right.
Really sad that of all days today this has happened.
And at this juncture, otherwise,
Yeah. Oh,
you
she's
should.
back.
Great.
Vishnu ji, please, Sonali madam को co-host credential दे दो, please.
Okay, ma'am.
हाँ जी. Thank you. Hi, Sonali.
Hi, can you? Hi, so sorry.
Yeah. Yeah, you were telling us
I
about
just
Section 9 practical tips, and you were talking about how Section 9 reliefs when you're drafting your Section 9 relief application, you need to tie those in with your final reliefs that you're seeking in the arbitration. I think we lost her again.
Professor, I have a suggestion.
Yes.
By any chance, if you have a phone number, if you could dial her and put her on speaker, then we could listen to her
Yeah,
through
but
your.
I think I asked Vishnuji already, and he seems to suggest that there is no methodology like that.
No, ma'am. All I'm
Vishnuji,
saying
कोई
is,
dial-in number है क्या Zoom के
no,
लिए,
ma'am.
or
What
do you
I'm
want me
saying,
to call her? Oh, okay.
yes, ma'am. If you just call her and put her on speaker, that
Yeah,
might be.
No,
I'll try that.
no, ma'am. मैम वो ओनली जो है ऑडियो करें अनम्यूट और वीडियो
हाँ
को ऑफ कर दें, स्विच ऑफ कर
हाँ
दें, फिर उसके बाद
हाँ
ऑडियो आ जाएगा.
हाँ जी.
वीडियो बैंडविड्थ जो है ज्यादा होता है, तो इसलिए जो है ऑडियो ओनली.
हाँ जी. Apologies, everybody. I'm trying to rebuild contact with Sonali. She's already online, actually. I can see her online. No, again, we've lost her. So I think yeah, she's back online. And we lose her again. Yeah.
Akansha, can you hear me?
Hi, Sonali. Yeah, you can maybe unmute yourself and you can keep your video off. I think that way we save on the bandwidth at your end. Does that make sense?
Hello, can you hear me now?
Sorry, we can hear you perfectly well. You can
Oh,
keep your
sorry for
video
this.
off. It's okay. I
Yeah,
think
I
it's just
think I'll have
some
to.
network bad weather issues maybe or whatever.
I think so. I'm so really
Yeah.
sorry to everyone about this.
No, it's all
But
right. So yeah,
anyway,
you'd
so
stopped. We lost you when you were talking about Section 9, India seated arbitrations practical tips, and you were telling us how it's always better to structure your Section 9 reliefs as if you are going to tie them in with your final reliefs. That's what you were talking about. That's where
correct,
you
right.
stopped. Yeah.
So what I'm saying is, suppose, for example, your Section 9, relief is, suppose your arbitration relates to, say, transfer of shares, okay, in a particular company, and your grievance relates to the fact that a particular transfer is not being made, whereas your Section 9 relief talks about, certain changes in the management or something which is not within the scope of your agreement. The Section 9 court may not be very inclined to grant you these reliefs unless you're able to really show that how they tie into your final reliefs in your arbitration. So again, this has to be carefully structured. What I've also already told you is that your arbitration needs to be initiated within 90 days. And the other thing is that you have to remember one thing, that if your Section 9 relief gets rejected for some reason, it does impact the way that you are seeking that relief before the tribunal, and also vice versa. Suppose you have already gone to a tribunal and sought a particular relief which has been rejected, then coming to a Section 9 court, is going to be an issue. And this actually happened in this Ashwini Minda Delhi High Court decision, which I'll also touch upon shortly, but that has, happened in a recent case as well. So these are just, certain basic principles of Section 9. You have to tie these into your specific Relief Act basic principles as well. You have to plead the fact that you have a prima facie case, that you have this balance of convenience in your favor, irretrievable harm and injustice would be caused if you're not granted these relief. So those are your specific Relief Act principles, which also apply to your Section 9 pleading. Am I audible now?
Yes.
Okay, great. Now I think let's move on to a very, very tricky, area, which is applicability of Section 9 proceedings to foreign seated arbitrations. Okay. There is one area of this Part 1 arbitration, which is Section 17. I'll deal with Section 17 when I'm talking about the Amazon future dispute. Okay. Because that's where it really will come into a better appreciation. So I'm just parking Section 17's discussion for the time being. Let's move on to Part 2. Now, I will need to take you back a few years, okay? More than a few years, I think 15 years. I will need to take you back to 2002, wherein a very important decision of the Supreme Court was passed in the case of Bhatia International versus bulk trading. I think the citations you probably already have in your textbooks, where it's a 2002 4 SCC 105. Now, in this case, an arbitration was seated in Paris under the ICC rules of arbitration, okay, institutional rules. And while the arbitration was going on in Paris, an application was made under Section 9 to the Delhi High Court, where an order of injunction was sought restraining for a transfer, alienation, or creation of third-party rights on the property. Now, this application was strangely held to be maintainable under Section 9, even though the entire arbitration was being conducted in Paris. But what the court ultimately, it went up to the Supreme Court, and what the Supreme Court ultimately held is a very important finding which sort of influenced the decisions of the Supreme Court for the next 10 years. What the Supreme Court said is that if a arbitration is seated in India, then the provisions of Part 1 will compulsorily apply, and that's clear. But in cases of international commercial arbitration held out of India, the provisions of Part 1 would apply unless the parties by agreement, express or implied, exclude any or all of its provisions. Now, this is a very, very important finding where they've said that Part 1 of the Arbitration Act, which ought to apply only to arbitration seated in India, will also apply to foreign seated arbitrations unless the parties have decided otherwise. And that decision of the parties can either be an express decision or it can be an implied decision, but they have to opt out of Part 1. Otherwise, Part 1 applies. So what it essentially did was that it expanded the scope of Indian courts to interfere in foreign seated arbitrations, particularly in the context of Section 9, because this case was in the context of Section 9. Now, obviously, this case has been criticized a lot. It was also been overruled 10 years later in the case of Bharat Aluminium, which is BALCO. But one thing you must note is that the idea of the judge at that time was to understand that foreign seated arbitrations have no way to protect the assets if the assets are in India other than Section 9. Because Part 2 doesn't have a corresponding Section 9 provision. Only Part 1 has it. Now, if, for example, you're sitting in Singapore, the assets are in India, they're being sold away, and you finish your arbitration after 1 year and you come to India to enforce it, what are you going to enforce it against, right? So that's a very important lacuna, which was identified way back in Bhatia. Obviously, the manner in which they dealt with it was criticized heavily, particularly in the international arbitration community, because they're like, oh, this is overstepping by Indian courts where they don't have jurisdiction, and rightly so. They did not have jurisdiction. Now, after Bhatia, what happened is that for 10 years, this trend continued. Okay. And even though Bhatia was a Section 9 case of interim reliefs, the other courts in other wrong decisions went on to say, okay, now if Section 9 is available, then Section 11 also should be available, which is appointment of arbitrators. Then Section 34 also should be available, which is relating to challenge proceedings. And it created a big mess. All right. Then came Balco in 2012. But before that, there are a couple of decisions which, we don't really need to study in detail, but you should just know that it came out with this theory of implied exclusion and express exclusion, which had its root in what Bhatia had said. But there were a number of judgments which went into this elaborate discussion of what happens when parties choose a foreign law, a foreign seat, and if the arbitration is being conducted abroad, so foreign venue, then is it an implied exclusion of part one? That means impliedly the parties are saying that part one is not to be followed. And the courts came out with this sort of theory that if parties have chosen everything to be foreign, then they have impliedly excluded part one. Then came Balco. Balco in 2012 said, this is wrong. Sorry, Bhatia, even though continued for 10 years, not right. And they completely reversed the position. And they made life very, very clear in terms of the way the act is structured. They said part one will only apply if the arbitration is seated in India. Part two will only apply for foreign awards being brought in from outside. Too bad if you don't have Section 9 relief. Literally, like Balco said, we can't help it. We are not the legislature. The legislature is not given provisions for a Section 9 interim relief for foreign seated arbitrations. Tough luck. Okay. And Balco was correct in interpreting the act the way the act is structured. Okay. And the legislature obviously recognized the lacuna. And that is when the 2015 amendment came in. And that is the most crucial amendment that was made to Section 2, the proviso to 2.2. Okay. Nirja, if you can just project that part, or
I'll just do it.
Akansha can project it. It's
Yeah,
important for
section. Okay.
Yeah. So the proviso to 2.2. Yeah, this is very important to note. It says subject to an agreement to the contrary. So above that, it says this part shall apply where the place of arbitration is in India. And it says subject to an agreement to the contrary, the provisions of 9, 27, and 37.1a and 37.3 shall also apply to international commercial arbitration. Actually, it's 1B that's been corrected. Shall also apply to international commercial arbitrations, even if the place of arbitration is outside India, and an arbitral award made or to be made in such place is enforceable and recognized under the provisions of Part 2 of the Act. Now, this means that even if today you have an arbitration seated outside India, say in Singapore, the provisions of 9, 27 and 37.1b and 37.3. So 9 is your ability to approach courts for interim reliefs. 27 is taking court assistance for for situations in, say, evidence, or sometimes even in situations of like contempt. Okay. So, and I'll also deal with 27 in some time. And 37 is an appeal provision. It's an appeal provision from 9. So essentially, the legislature is granting, arbitrations seated abroad the ability to come to an Indian court and ask for interim reliefs. Okay. The only thing it says is subject to an agreement to the contrary. Now, unfortunately, what has happened is that our legislature sometimes ends up skipping some crucial words. Okay. And this happened even earlier when there was the whole Balco debate. But this crucial skipping of words is the word express. The Law Commission, the 246 Law Commission report had said the language should be provided that subject to an express agreement to the contrary, the provisions of 92737 would apply. But the word express was dropped when this act got amended. Okay. So I think we can stop the screen sharing. Yeah. So because of this issue of the word express not being included, then practically we have seen people come up with very innovative arguments to say that okay, that means that there can be an implied agreement to the contrary, and parties can impliedly agree that the provisions of Section 9 will not be applicable to a foreign seated arbitration. Okay. And there have been a lot of schools of, right. You can see
This
that,
is the
you
Law
can see the
Commission
word
report.
express. Yeah, you can see, insert the proviso subject to an express agreement to the contrary. And because the word express was dropped, very innovative Indian parties came up with this argument in court, saying that, because it's a foreign seat, it's a foreign law, foreign venue, relying on the earlier the Bhatia regime judgments means parties have impliedly excluded Section 9. So therefore, you can't come to an Indian court for interim reliefs. Now, this agreement this argument actually makes no sense, because the whole reason why the amendment was introduced was to give ability to foreign seated arbitrations to come to an Indian court for interim reliefs if the assets are in India, right? Now, that was the logic, that was the purpose, that was the spirit of the amendment. Now, the minute you start making a contrary argument, okay, just 1 second, sorry. The minute you start making a contrary argument to say that no, there can be an ability for implied exclusion even today, okay, that just negates the whole purpose of this amendment, right? So I'll be honest that courts have entertained these kind of arguments. Okay, in fact, I am currently engaged in a Section 9 proceeding in Madras, where arguments of this nature are being made. The decision is not yet out, but the point is that by leaving out one word, there is at least the room for arguments of this nature. Now, in this case, there are two important decisions and two different schools of thought between the Bombay High Court and the Delhi High Court. So you should just note these decisions, and I would certainly urge you to read them in your spare time, whenever you get time. So one is the decision of Raffles. I'll just give you the citation. It's Raffles Design International India Private Limited versus Educom. And the citation is 2016 SEC Online Delhi 5521. Now, in this case, what Raffles held was that your exclusion of part 1 can be either express or implicit. Okay, so they went back into the pre-Bhatia regime a bit to say that even impliedly you can try and exclude part 1, because they were interpreting this language, right, in the proviso, it's subject to an agreement to the contrary. To this, they were like, you could possibly have an implied exclusion as well. Thereafter, the Bombay High Court, in the case of Heligo Charters, this is Heligo Charters Private Limited versus Aircon. This decision basically said that, we are not inclined to accept that you can have an implied exclusion. And they said that you need a specific agreement. They use the word specific agreement to the contrary. Now, the word specific is again not included in the act, but this is what the interpretation of the Bombay High Court was. And that obviously means that it was gearing towards an express exclusion. And that, at least in my personal view, is the more correct interpretation, because if you can start building in implied exclusions, then parties get the room to argue that Section 9 is not available, which could not have been the intent. So this is essentially where we're lying today in terms of foreign seated arbitrations being able to come to Indian courts and being able to seek interim reliefs. Now, in a way, it's a good amendment because parties are, protected in terms of their assets. Okay. And I think once this issue gets clarified by the Supreme Court as well on whether it's an express or an implied exclusion, then it will put to rest even this minor sort of loophole, if you can call it that, which exists in the language about an agreement to the contrary. And then this whole position will get solidified and there will be no room for debate. So I think we just need to await a decision of the Supreme Court on this issue. But otherwise, generally, Bombay High Court, Madras High Court, Delhi High Courts, they have all, I think there's also Punjab and Haryana High Court decisions, have been giving Section 9 reliefs in aid of foreign seated arbitrations. So which is obviously a positive trend, and we hope that it continues. Now, what I mentioned to you earlier is, in certain cases, if you have, in the Raffles decision, what happened is that a award that was an emergency arbitrators award that was obtained outside the country, there's no way of enforcing it directly here. So the only way that you can really do it is you file an independent Section 9. It's not linked to your foreign order. You have to file it independently. You will annex that foreign decision from the foreign tribunal's decision to your Section 9 petition, and you will seek probably the same reliefs, or you may seek further reliefs. Because in Raffles, what happened is there was an order that was passed, and then there was non-compliance of the order, and there was a further breach. So then they came to the Delhi High Court and they said that, look, we already have a foreign award. We're not enforcing that because there's no direct way of enforcing it. But we're seeking Section 9 reliefs, which are identical or in furtherance of that relief. So that relief was granted. So what I'm trying to say is that there is no direct way of enforcement of a foreign tribunal's order in India yet. What parties do is use Section 9. They use this proviso 22, and they use Section 9. And then they seek the same relief from an Indian court. Now, I'd also mentioned this decision of Ashwini Minda. Okay. I'll just give you the citation also. Just give me a second. It's, it's 2020 SCC Online, Delhi 721. So it's Ashwini Minda versus Yu Shin Limited. Okay. It's 2020 SCC Online, Delhi 721. Now, in this case, what happened is that arbitration had been commenced in Japan under the JCAA arbitration rules, which is the Japan Commercial Arbitration Association rules, okay, which was an institution there. And the emergency order sought from the arbitrator in that matter was refused. After that, the party came to the Delhi High Court under Section 9 and sought the same relief. To which then the court said that, look, once you've exhausted that remedy and you have been refused a relief, the proviso to 2.2 should not be read to mean that you can have a second bite at the cherry. And therefore, they said you can't come back to Section 9 and then ask the same relief from an Indian court, because that is not the idea of providing the proviso to 2.2. So essentially, Ashwini Minda really again says that it's not that you can't come and file a Section 9. Obviously, there's no direct way to enforce a foreign order, but once you've already been rejected at a particular forum, you cannot have a second bite at the cherry under Section 9. Okay. So these are essentially the important decisions under Section 9 for foreign-seated arbitrations at the moment. There's another decision of Avitel, and I'll give you the citation in a bit, but the Avitel decision was also a similar decision where we'd gotten this was a case where AZIV was also involved, and we'd gotten a foreign arbitrators award, which we're not trying to seek to enforce directly. They tried to file a Section 9, which was upheld on the same and identical reliefs. So that is how parties are, once again coming to an Indian court for the interim reliefs, which would have been granted by the foreign tribunal. Okay. Now, coming back to actually now let's deal with 27, okay, because we've dealt with 9. 37 is just an appeal from 9, but 27 is an important provision, and 27 is being sort of discussed a fair bit now, given that there are times where certain foreign tribunals orders are not complied with by parties. Okay, then 27 is one route that is most certainly being discussed academically, at least, and you may find parties filing proceedings under 27 also shortly. So 27 essentially is talking about court assistance in taking evidence, which is fairly routine. So for example, if you have a witness in India and your tribunal is seated abroad, and if you need court assistance in taking evidence from the witness, that's a fairly straightforward thing. What is really important to note is 27.5. Okay. Can I request you, Akansha, to just put up 27.5? Do you have the act? Yeah. Yeah. Now, persons failing to attend in accordance with the process or making any other default or refusing to give evidence or guilty of any contempt to the arbitral tribunal during the conduct of arbitral proceedings shall be subject to the like disadvantages, penalties, and punishments by order of the court on the representation of the tribunal as they would incur for the like offences in suits tried before the court. What does this mean? This basically means that if you see the language, it says either you fail to attend the process, which is the court process, or you make a default, or you are guilty of contempt to the tribunal during the course of the arbitral proceedings. Now, you have seen that this provision applies now to foreign-seated tribunals, right? Which basically means that if tomorrow a Singapore-seated tribunal passes an order of injunction against an Indian party and the Indian party flouts it and says that, we're not going to comply with it, there is no way to directly enforce that tribunal's order in India. But because 27 is now available for foreign-seated arbitrations, this is maybe one mechanism by which you can request the tribunal to make a request to a court to then initiate contempt proceedings for, if you can see the language, guilty of contempt to the tribunal during the conduct of the arbitration proceedings. You can close this, Akash. So this is, practically being discussed in one of our matters. Also, we were thinking that we could possibly go and file a 27.5 because ultimately the court needs to enforce these foreign orders. And if there is contempt of a foreign tribunal's orders now, because 27 is applicable, then this provision should be available. So do watch out the space for 27.5 decisions also. I do expect them. So I do expect several decisions to sort of come out on this. Okay, so now I think, in case you guys have any questions on 9, I thought we could move on to the space of an emergency arbitrator, and we could possibly discuss the Amazon Reliance case. But I'll pause here for a minute. Please feel free to, voice any comments or any questions that you have. And, I'm happy to take them now before we move on to the topic of emergency arbitrators. None? Everyone's understood everything?
You can maybe unmute yourselves or you can raise your hand and I can call out on you.
Either you understood everything or you understood nothing. So I really hope it's not the latter.
Like maybe you can continue and we can take questions in the end. I think Sonali is frozen again. I think Sonali is unfortunately frozen again. Yeah. So sorry, I'll just try and get Sonali back on the call.
Hi, can you hear me, Akansha? Sorry, I can't hear you.
Yes, yes.
Okay, sorry. I just think there's some digging work going on in my house, which is why it's just unfortunate. But sorry.
Yes,
So
okay.
are there any questions before we?
Yes, there are a couple of
Uh,
questions. There's someone who wanted you
Sure.
to repeat the position in Avitel. And then there's another
Okay.
question that's asked us if there are any real cases which enforce foreign awards through 27.5 or is it just a possibility? So I've
Okay.
given them Alka Chandewar versus Samshul, Supreme Court. They've already said that yes, you can use 27.5. There are a couple of more which you can tell them about.
But Alka did not act, was not a case under 27.5.
Yes, exactly.
It
It's
only
a
recognized,
passing reference that allows
yeah,
it. Yeah.
yeah. So
Yeah.
actually, there are no cases yet.
Yes.
In the Amazon case, I think there is a contempt filed, but Amazon, please remember, is an India-seated arbitration. It's not a foreign seated, but even so, it is in that sense contempt of an arbitral tribunal's order, and they have tried to invoke. It's not yet, the decision is not yet out, but they have referred to 27.5. So you should definitely watch the space for 27.5 in the Amazon case as well. What Alka Chandeshwar says is that 17 by itself has no teeth. And therefore, in the context of enforcement, if you don't comply with the provisions of 17, and please remember, I think that was pre-amendment when 17 did not have teeth for enforcement. So they said that you then can approach a court under 27.5. Can you hear me now, Akansha?
Yes, perfect. Yeah.
Okay, great. The Avitel decision essentially was a Singapore-seated arbitration. where there was an award from an interim award from an emergency arbitrator, not directly enforceable. And they had filed a separate independent Section 9, okay, in the Bombay High Court. The argument taken on the other side was that this is what you can't do directly, you can't do indirectly, right? That's a settled principle. So they said that what you can't do directly in terms of enforcement of a foreign or award or order, you can't do it through a Section 9 proceeding. But the court did not accept that argument and granted reliefs, which applying its independent mind under Section 9. Okay, and that's what I'm trying to draw the distinction on, that while there is no direct way to enforce a foreign tribunal's order, interim order, the courts now, under the proviso to 2.2, have the ability to independently look at the facts of the case and grant suitable interim measures for foreign seated arbitrations. Are there any other questions?
Yeah, I think that's it. Maybe we can continue. And
Yeah,
then
I
take
actually
questions.
have had my hand up for a while. This is Mansi
Ansi,
Kumar
I'm so
speaking.
sorry. Yeah.
Yeah, no worries. Hi, my name is Mansi Kumar. I'm actually an associate professor at
Yes.
Jindal. I just found this very interesting, so I wanted to log in. I actually was wondering, Sonali, if you could just clarify. I find it very curious that Section 9 has been created subject to an agreement to the contrary, because it makes me think about in what circumstances can we envision, apart from the discussion about express versus implied, in what circumstances can we envision parties expressly agreeing to keep certain property away from any threat? And because I have never encountered something like that, ever. And I have done some practice, but I mean, I would be very interested to hear your experience. I've never encountered parties carving out an exception for certain property and having that be agreed to, no matter what one might want, having that be agreed to. So as a drafter, one would ordinarily put this in that sort of academic language of, well, we're not going to be bound by Section 9 of the Arbitration Act. It makes me wonder, though, is the recommendation, even by the Law Commission, has it actually been I mean, what is the thought process behind that? If a negotiation is unlikely to yield agreement on certain property being off limits, despite whatever dispute may arise, what other rationale could there be for the Law Commission of put in subject to an agreement to the contrary in this regard, other than perhaps a fail-safe? They're thinking maybe there are some legitimate circumstances we can't think of. So I just wanted to hear your thoughts on that, please.
No, I think that's an excellent question. And obviously, logically, parties would not want to take out the remedy of Section 9, particularly if you have assets here. So practically the clauses that we are seeing, and that's the other practical tip that I just wanted to share with the group, is that despite 2.2 being available, in clauses today, we deliberately add the language to say that the provisions of 9, 27, and 37 shall be applicable to a foreign seated arbitration. So we're not leaving anything to chance. Nobody should be able to argue later that this is not applicable in any manner whatsoever. Just give me one. Sorry. So I think the reason why this was possibly provided is, like you rightly said, a fail-safe. It's probably, coming from the fact that arbitration ultimately, relies on the principle of party autonomy. And there could be a situation where two parties, may want to only limit themselves to a foreign tribunal's jurisdiction and a foreign court's jurisdiction over particular issues and disputes, and they do not want the dispute to get into the Indian scenario. There's also a lot of hangover optically from disputes entering into the Indian court scenario in the minds of foreign parties. And practically we have seen this kind of hesitation, saying that we don't want the dispute to get stuck in an Indian court, so we just want to exclude it entirely and just be stuck to a foreign tribunal's jurisdiction. And if they have means of recovery of that same amount through assets abroad, it's ultimately monetary, in nature, the award that will come out. And if there are other means of recovery of that assets through certain other, foreign assets, then parties could sometimes also agree to exclude the provisions of this part completely. But not that often. It can just be very, very few instances. More often than not, parties do end up putting a specific provision now to say that 9, 27, and 37 will be available.
Thanks so much. What I find really interesting about your answer is that the contract is not to the contrary, what you're suggesting, but now the contract is reiterating what the statute is providing.
The reason we've done that, sorry to interrupt, the reason we've done that is because there are certain parties who are taking this argument of implied and express. So we're saying there's no question of an implied. I'm telling you expressly that I am opting in, even though I don't need to opt in. But I'm expressly opting in just so that this confusion of agreement to the contrary is thrown out of the window.
Yeah. It's very, very interesting. Thank you very much.
Thank you. Okay, so now let's move on to this very interesting topic of emergency arbitrators. This concept, has originated from the rules of institutions, arbitral institutions, which provide for the appointment of an emergency arbitrator very, very quickly, possibly within a few days of the dispute arising, if there is danger to the property or if urgent interim reliefs are required. So, say within 48 hours, if you write to CAC and say that, look, I need urgent interim reliefs, CAC will get somebody from its panel appointed as an emergency arbitrator. You can go before such arbitrator and you can present your case for the limited purpose of seeking interim reliefs only. And this arbitrator's order is subject to, is valid till the main tribunal gets constituted. Once the main tribunal gets constituted, the tribunal has the powers to either vacate it or modify it or adopt it as it deems fit. But there's also, I think CAC also has a time limit of 90 days to this emergency arbitrator's order as well. So the idea of emergency arbitrators originated because institutions wanted to give parties that protection or the option to go and seek urgent interim reliefs, not from a court, but from the tribunal itself. And therefore, they say that we will appoint somebody very, very quickly, and you can approach this person for any kind of interim reliefs. Now, I'm pretty sure you've read about the Amazon future dispute in the press. So I don't want to get into too many details on the factual aspect, but you can basically just think of it as like two grooms fighting over one bride, right? So, you have the business of future, which is a $3.4 billion retail asset, and they are being there's a tug of war going on between Amazon and Reliance for that business, right? Now, Amazon is claiming that they had invested 1,400 crores in future, and their agreements basically prohibited future from selling off their business to anybody else, but particularly the Ambanis, particularly Reliance. Reliance was mentioned there by name. So there was a clear prohibition, according to Amazon, that Future could not have sold its business to Reliance. Future is also hitting back and saying, sorry, they have a number of defenses, but they said that this agreement is not, this is the wrong interpretation of this agreement. And what you are claiming is under some separate agreement to which Future Retail, which is the entity that has sold its business to Reliance, saying we're not a party to that agreement. So they're taking that argument. And they're obviously saying there's no prohibition. we could have sold to Reliance, and we are selling to Reliance. So the dispute essentially is between these three parties, but the arbitration, okay, is between Future and Amazon, because those are the two parties to the arbitration agreement. Okay, even though Reliance is an interested party, to the agreement, they are not a party, obviously. Now, Amazon started a dispute, an arbitration proceeding in Singapore in October of 2020. Okay, and they approached an arbitral tribunal. They approached an emergency arbitrator in Singapore, seeking for a stay or a blanket stay on any action to be taken by Future in furtherance of this transaction with Reliance. And they said that you can't go ahead with this deal. On 25th of October 2020, the emergency arbitrator passed an order in Singapore. Please note once again, this arbitration seat is India, venue is Singapore. So part 1 applies. Don't get confused by this. Just because the proceedings are happening in Singapore does not make it a foreign seated arbitration. And of course, Akansha is going to explain this concept of seat and venue in more detail during her lectures. But keep this in mind, that the Amazon dispute was an India seated arbitration, which means Section 9 applies, Section 17 applies. Despite that, they went to the emergency arbitrator under SIAC, and they have invoked the provisions under the SIAC rules. So the SIAC arbitrator passed an order in favor of Amazon, restraining Future from proceeding with the Reliance deal. Future thereafter has refused to comply with that deal on a number of reasons, which they say that, including that they are not bound by the order, they're not parties to the agreement. And initially, Future filed a case, a suit in the Delhi High Court, taking numerous grounds, saying they're not bound by this decision. And basically, Reliance, it was a case also on tortious interference, to say that Amazon should not interfere in the deal between Future and Reliance. Okay. Separately, and this is where it gets interesting, separately, Amazon has now filed a petition in the Delhi High Court to enforce the order of the emergency arbitrator under Section 17 of the Act. That's where we now need to look at Section 17. And there's a little bit of history to the amendment also that was made to Section 17 in 2015. So now you'll be able to appreciate why that's so important. But if you come to Section 17, Akansha, can I trouble you again? Sorry, can you? Right. So if you see, it says a party may, during the arbitral proceedings, apply to the tribunal. Now, A, B, C, D, E, they are all identical to Section 9. If you scroll down, the tribunal, scroll to the next page. Yeah, and the tribunal shall have the same power for making orders as the court has, for the purpose of and in relation to any proceeding before it. Now, very importantly is subclause 2, okay, 17.2. Subject to any orders passed in an appeal under 37, any order issued by the tribunal under the section shall be deemed to be an order of the court for all purposes and shall be enforceable under the Code of Civil Procedure in the same manner as if it was an order of the court. Okay, now the history to 17, unfortunately, is that prior to the 2017 amendment, 17 did not have any teeth in terms of enforceability of its orders. So even though tribunals would pass an order, the parties would necessarily need to go to court in order to enforce that decision. Okay. And this was, I think there are 2-3 decisions here that are important. I think there's a Madras High Court decision in Sundaram Finance. I'll give these citations to Akansha and you can have a look at these judgments. But in that case, it basically said that whenever a tribunal passes an interim order under Section 17, it thereafter needs to go to court for the purposes of enforcement. Okay. And there's another case of the Kerala High Court, which is Pradeep KN, which is a 2016 case. And here, I think the tribunal had passed an order about impounding of some car. And that also obviously could not be enforced. You had to basically use the police mechanism through the court to be able to give effect to the tribunal's orders. Okay. But after this amendment, essentially what is being sought to be propounded is that the tribunal does not, after a tribunal passes an order under 17, it does become automatically enforceable. You don't have to then separately apply to a court for the court to give its stamp of approval on a tribunal's order in the section 17. Okay. So what Amazon has done is that it has filed a petition for enforcement under 17(2) before the Delhi High Court. Okay. As well as, I think, even Order 39 of the CPC, but essentially 17(2), to say that this order is enforceable. It is an order under 17. So you can shut the screen share. So interestingly, what they have said is that this emergency arbitrator under the CAC rules is an arbitrator for the purposes of the Act. And this arbitrator has passed an order. You may call it an emergency order, but it's an interim order under 17. It's to be treated as if it is an order under 17. Therefore, it is enforceable under 17(2). It's a very interesting argument that they've made, okay? Because you have to understand, right? What's happening here is that the arbitration is being conducted with a seat in India. So the Arbitration Act applies, but it is also being conducted in accordance with CAC rules. So the rules and the Act have to interplay with each other such that for every non-mandatory provision of the Act, the rules sort of become an agreement of the parties. Okay. So as far as treatment of the emergency arbitrator as an arbitral tribunal for the purposes of the Act, the argument that was made is CAC rules treat an emergency arbitrator as an arbitrator. Parties have included CAC rules into the clause. Therefore, parties have agreed that the emergency arbitrator is an arbitrator. Therefore, his order is a 17 order, and therefore it needs to be enforced. So this is the petition that is pending before the Delhi High Court right now. Justice Midha of the Delhi High Court on 2nd of Feb 2021 passed a prima facie order saying he's in agreement with the arguments being made and the fact that this is to be enforced. So he ruled in favor of Amazon and granted a status quo order. That status quo order on the transaction, that status quo order was challenged before a division bench, which has put a stay on the status quo order. Okay, and now this has gone to the Supreme Court. So as far as the proceeding is concerned, this is the stage where we're at. So I would certainly request all of you to watch the space and watch the news to see what the Supreme Court decides. And Justice Midha also has to give a detailed order on this entire argument that I just told you about, which is that enforcement under 17(2) is permissible, and an emergency arbitrator is an arbitrator under the definition of the Act. Now let's see what the definition under the Act is, because that's a little important to see. That you need to go to 2D, okay, section 2, subclause D. It says arbitral tribunal means a sole arbitrator or a panel of arbitrators. Okay. Now, this was argued to mean that the minute you say sole arbitrator, an emergency arbitrator would fall within the ambit of a sole arbitrator appointed by the parties, because the CAC rules treats an emergency arbitrator as a arbitrator. And you have to note one more thing, which I don't want to trouble Akansha, so I'll just tell you. The 246th Law Commission report had a specific amendment which was suggested. Yes, thank you so much. Thanks. So Akansha is very helpfully put up. This, if you see the wording on the screen, this is the wording after the panel of arbitrators. The Law Commission had recommended that you please add that in the case of an arbitration conducted under the rules of an institution providing for appointment of an emergency arbitrator includes such emergency arbitrator. Now, this was not accepted, okay? This language of the Law Commission report was not accepted in the 2015 amendment. So the argument is made by certain parties to say that because the amendment was not included, obviously the legislature does not intend to include an emergency arbitrator within the definition of an arbitral tribunal. A counter argument to that is what Amazon made before the Delhi High Court, to which Justice Midha has prima facie agreed, to say that no, the minute you choose the SEAC rules, the parties have agreed that an emergency arbitrator can be the sole arbitrator included within the definition of 2(1)(b). Okay, you can close that. You can stop the screen sharing. So currently, this is the position in the Amazon future dispute. There are lots and lots of interesting issues that are at play, which will ultimately be decided by the Supreme Court, and that's going to have a huge impact on how the courts in India treat emergency arbitrator orders and whether they are enforceable or not. But please note that this enforceability is through Section 17. Section 17 is only available to India-seated arbitrations. The position will not impact a foreign tribunal, foreign seated tribunal in which you get an emergency arbitrator's order, and that you will not be able to enforce that through Section 17 because Section 17 is not applicable for Part 2 arbitrations. So if my arbitration seat is Singapore and my Singapore tribunal passes an interim emergency arbitrator order, there is no way that I can bring it into India for direct enforcement. That is what my earlier part of the talk dealt with. Then you will come in a Section 9 independently. You may rely on that order, but only as an exhibit. You'll file a separate Section 9 and try and convince the Indian court to grant you the same release. But for an India-seated arbitration, like the Amazon case, you can try the Section 17 route for enforcement of an emergency arbitrator's order, subject to what the courts ultimately decide, ultimately what the Supreme Court will decide in the matter. Yeah. So I think that sort of I come to the end of what I wanted to talk about. I'm happy to take in any questions on this. Like I said, it's a very, very interesting, complicated, and a diverse topic. So it requires a lot more time, a lot more discussion. Obviously, once you've read the judgments, you may have more questions. But right now, if you guys have any top level questions, I'm happy to take them.
All right, great. Thank you so much, Sonali. So what we can do is you can either unmute yourself and switch on your cameras to ask the question. It just increases interaction with our speaker. Or else, if you can't and you're struggling with internet, you can just type out your question in the chat box, and depending on how time permits us, I'll relay it to Sonali. So please do definitely ask any and all questions that you may have. How can there be no questions?
Like I said, there can be two completely contradictory outcomes to this discussion. Either you've understood everything or you've understood nothing. I really hope it's the former.
All right, I'll begin, and maybe then it just lets everybody else ease into asking questions. So there was this thing that you mentioned when you were discussing the Amazon future dispute about how there is a reference to the nature of Section 9 versus how Section 9 gets used vis-a-vis 9 and 17 end up getting used for foreign seated emergency orders versus emergency awards, where you talked about how the language of provisions in the statute itself may not be mandatory, and therefore non-mandatory provisions get incorporated into the act to be invoked later for enforcement. Can you please explain how the provision as non-mandatory can still be made enforceable by one party to an arbitration proceeding?
So the context in which I mentioned this is that some people get confused in terms of how institutional rules apply while the act applies to an arbitration. Okay. So suppose it's an India seated arbitration, 100% part one of the Arbitration Act will apply. But at the same time, you are saying the rules of CAC will also apply, the ICC rules will apply. So how do the two tie in? How do the two work in tandem? This is a question that crops up often as a doubt. The way it works is that the rules are treated as being incorporated within the clause by reference. So the minute you say the rules of CAC shall be applied, it basically means all the rules are agreed by the parties as an agreement. They don't have to specifically say, I agree to clause this rule, this rule, this. No. The minute you say rules apply means whatever is in those rules will automatically be incorporated as an agreement by the party. So an agreement to the contrary. And I'll give you the simplest example of this. Okay. Suppose the act says you have 30 days to respond to a statement of claim filed by the other party. So say statement of claim filed by claimant, within 30 days, the statement of defense shall be filed, right? Now that timeline is a non-mandatory timeline because it is subject to an agreement to the contrary. Now, if the CAC rules gives me 45 days, because I have incorporated the CAC rules, the 45-day timeline will apply. It's called, that is a non-mandatory provision by which the CAC rules will, the provision of 45 days therein will become the agreement of the parties to the contrary. Okay. What is a mandatory provision? Now, under 29A, it says that your arbitration must get over within 12 months. That's a mandatory provision. It can be extendable to 18 months with the consent of parties, post which you have to go to court. Suppose you had an institutional rule which said that the tribunal has 2 years to complete an arbitration. There's a clash, in which case your mandatory provision of the Indian Arbitration Act will override your CAC rule provision of 2 years. CAC rule doesn't have such a provision. I'm giving you an example. So there are certain provisions in the Act which are mandatory, and that you have to really judge from the language of the provision. If the language says subject to an agreement to the contrary, you know that the parties can have a contrary agreement incorporated through a rule, through institutional rules. But if otherwise, the provision is mandatory, it is. For example, I'm just giving you another example, that the agreement has to be in writing. Section 7, mandatory. There may be certain foreign rules which may allow for a oral arbitration agreement also. It's irrelevant because your act ka section 7 is mandatory. It will override rules. So this is an analysis that needs to be done basis each provision, but the test is to see what can be termed to be non-mandatory, what can be mandatory, and then see how the rules interplay. So that's the context in which I mentioned the Amazon dispute. Now, in that case also, because it's in India seated arbitration, it doesn't matter because the entire part 1 will apply anyways.
Yeah. And the CAC themselves, I think, have started saying that irrespective of where in the world you are, the CAC rules can be used wherever your seat is, because the CAC is happy to help you administer a CAC rules style ad hoc arbitration, which
Absolutely.
is the CAC's methodology of trying to get those rules used.
Their rules with each country's act. Now, the reason why they had referred to the CAC rules, Amazon, is to say that the rules treat an emergency arbitrator at par with that of an arbitrator. So therefore, you and in the Indian Arbitration Act context, nothing prohibits an emergency arbitrator from being treated as an emergency as a sole arbitrator if the parties agree. And here the parties have agreed under the rules. So it is an interesting argument, and we obviously need to wait for the more detailed order to be passed by Justice Midha, because right now I think on 2nd Feb it was a prima facie, a 6-page order. We'll wait and see how he reasons it. And then it will be interesting to analyze this argument further.
So I have a question in the chat box, and I'm going to rephrase that question a little bit because I was going to use it as a follow-up question anyway. So Aditya Mishra is asking, why did Amazon not apply for a relief under Section 9, considering the same was allowed in raffles? To which I'll add a follow-up that there is a distinction between interim order versus an emergency arbitrators award, in which the emergency tribunal is outside of India. So that's where I think the whole Section 9 response can come in. So the question is, why did Amazon not apply for relief under 9 and instead use SIAC? That's the
Akansha, I think
question. Yeah.
Amazon is saying that the emergency arbitrators order is not an award.
Correct.
Therefore, they are not saying it's enforceable. They are saying it's an order only, then interim order under 17. So the question is interesting. It's right that they had, because it's in India seated arbitration.
Could have used 9.
You could have used 9, they could have used 17. Okay. Now, obviously, Amazon is being like advised by the best lawyers available. And they possibly thought, and this is just a guess from my side because I'm not involved in the dispute, so I wouldn't be able to give any insight on that, but it's just a guess that, considering the fact that an emergency, because the arbitration had already started, they had initiated the arbitration. And they probably did not want to get into the whole issue of what efficacious alternate remedy is, whether the relief is efficacious, not efficacious. And because SIAC provided for an emergency arbitrator to be appointed expeditiously, they possibly thought that is a good route to take, because ultimately that is what the parties had agreed to under the rules. So while parties have other options, Section 9 is also a threshold. You have to show that efficaciousness there for them to really interfere. So you're right in your question that it was available, but it was a strategy call for them to go to the emergency arbitrator, because that is also available under the rules.
More questions, please. You can raise your hands or unmute yourself or type it in the chat box. I just had one question in the chat box as of now. Yes, there's one more. Again, there's somebody who's calling themselves Android, so I'm sorry, I don't know your name. There's a question which says, what about Reliance in the Amazon future dispute? Can Reliance seek relief as a non-signatory in the courts under Section 9 or through the CPC? Because it will be affected by the outcome of the court.
So, Reliance was party to the suit. I remember I told you that Future filed a suit for tortious interference. In that, they made Reliance a party respondent, because the reliefs therein would also impact Reliance. Under the arbitration mechanism, Reliance is a non-party. So in that sense, for a Section 9, maybe they could have been injuncted, but otherwise, Amazon is proceeding against its counterparty, that is Future. If they stop Future, the deal is anyway stopped, right? Because then it will not proceed. And they are the counterparty in the arbitration agreement. Reliance, in that sense, is a third party. It's a non-party to the arbitration proceeding. So there is a threshold issue for Reliance to file a Section 9. It can't, because like I told
There's
you
no
first,
clause.
right? There's no clause. The second thing is your Section 9 is always in aid of your arbitration proceedings. Please remember, your 9 has to refer to the clause. It refers to the fact that you intend to initiate arbitration if you haven't already. And your relief has to be in aid of your final relief in arbitration. Because Reliance is not a party, it can't do so. It has other remedies, but again, I don't think they're filing anything. They haven't filed anything yet. The proceedings that are pending so far, I've already told you about that.
Correct. Any more questions, anybody? I have a colleague from the Center for ADR who's also on call with us, Sakshi. If there's any follow-up, Sakshi, or a comment that you may want to make, please definitely do.
Hi, I don't really have a question,
Hi.
but this really complicated topic was very well explained. Thank you so much, Sonali.
Thank you so much. That's
Especially from
very
the
sweet.
beginning, like the basics, and you've given us some practical tips, which we really appreciate as in classroom if you have someone telling us that. Thank you so much, Sonali.
Very sweet. Thank you.
All right. More questions, anybody? All right, then I think we can stop. Thank you so much, everybody. And thank you so much, Sonali, again, in spite of
Absolute
all
pleasure.
the
Yeah, and I'm
in
so
spite of
sorry
all the
about the
struggles. No, absolutely
technological
not.
challenges that I don't know why I'm facing them today, but it's just bad timing. But thank you for being patient and for all those who didn't log off while I was struggling. That's very kind.
All right. Thank you so much.
Thanks. Bye.
Bye
Have a
bye.
good weekend, everyone.
Thank you.
Bye.
Bye bye.